All right, Nigerians, this Tinubu FBI files controversy is getting deeper by the day. And now a former American mayor has entered the conversation with a very serious theory about why some of these records may be kept away from the public. And I want us to be careful today because there is a difference between what the FBI has actually told the courts and what Mike Arnold believes may be behind it. Those two things must not be mixed together, because Arnold himself eventually called what he presented a working theory. So I am not going to sit here and tell you that Tinubu was an FBI informant when that has not been established by the court. But Nigerians, the questions Arnold is raising are serious, especially after what the FBI itself has already said about possible danger to lives. So let us unpack this properly. Before we go into the full details, please endeavor to like this video and subscribe so you don't miss what is coming next. Now back to the news. Mike Arnold is a former mayor of Blanco, Texas, in the United States. He is also the founder of Africa Arise International and describes himself as a strategist, political consultant, journalist, filmmaker, non-profit founder, and author. He has now reacted to the growing allegations that somebody may have paid the FBI, CIA, Judge Beryl Howell, or even President Donald Trump to stop the release of records relating to President Bola Tinubu. And Arnold is basically telling Nigerians, stop thinking about America exactly the same way you think about Nigeria. According to him, despite America's imperfections, the American system still has strong institutions, transparency, and rule of law. Therefore, he rejects the suggestion that somebody simply paid the FBI, CIA, Trump, or the judge to block these documents. Now, on that point, I think we need evidence before accusing anybody of bribery. It is very easy on Nigerian social media to say Tinubu has paid everybody. But where is the evidence? If evidence emerges that anybody was bribed, bring it. Until then, we cannot turn suspicion into fact. And remember, Judge Howell has previously ruled against government agencies in the same legal battle. So portraying the entire process as if everybody involved is simply working together to protect Tinubu doesn't fit neatly with what has happened in court. But then Arnold gets to the most interesting part of his argument. He says the legal reason being presented for withholding some information is actually plausible. Not necessarily correct, plausible, and that distinction is important. The FBI previously told the court that disclosure of certain withheld information could reveal law enforcement investigative techniques or procedures and could reasonably be expected to endanger somebody's life or physical safety. Arnold then asks the question millions of Nigerians are now asking, whose life? That is where his theory begins. He argues that these events happened roughly 33 years ago, so he believes it is extremely unlikely that the person requiring protection would still be an undercover operative connected to that whole investigation. From there, Arnold concludes that the protected person could instead have been an informant. Then he uses much stronger language. He calls such a person a snitch or a rat, and then he turns directly towards Tinubu. Arnold argues that because Tinubu himself has opposed the disclosure of the records, it could suggest that Tinubu has a personal reason for wanting the information protected. Then Arnold makes his biggest allegation. He theorizes that the resolution of Tinubu's American legal problems in the 1990s may not have involved only the forfeiture of $460,000. He suggests that Tinubu could also have provided information about other people connected to the alleged network. Nigerians, once again, that has not been established. Mike Arnold himself called this a theory. There is no court ruling in the material before us saying Bola Tinubu was an FBI informant. There is no disclosed FBI document before us establishing that Tinubu exchanged information for immunity. And there is no evidence before us proving that Tinubu provided names of other alleged traffickers. So we cannot turn Arnold's theory into a factual conclusion, but we can certainly examine the logic behind the questions he is asking. Because the FBI itself created this mystery when it told the court that disclosure could endanger life or physical safety. Naturally, people will ask whose life, and until the court process gives more clarity, speculation will continue. Now Arnold goes even further. He claims the alleged operation reached into what he described as the Southeast Asian underworld and involved people who were powerful then and, according to him, remain powerful today. Then he tries to connect the timeline. He points to what he describes as American action against criminal networks in that region after Tinubu left the United States. And he asks, could information allegedly supplied by Tinubu have contributed to those operations? Again, notice the language. It is a question, not established evidence. Arnold himself asks essentially, if Tinubu supplied that information, could disclosure today endanger him? And logically, yes. If somebody secretly provided information that helped law enforcement move against a dangerous criminal organization, exposing that person's identity could create security concerns. But we still have to establish the first part. Did Tinubu actually provide such information? That remains unproven in what we have here. You cannot prove B by simply assuming A, and Arnold doesn't stop there. He asks whether Tinubu could have provided names of prominent Nigerians. He even speculates that some of those people could today be politically connected to Tinubu without knowing what allegedly happened decades ago. Arnold argues that if something like that were true, disclosure could create a completely different danger for the president. And then he concludes with the phrase that is now getting attention. This is my working theory. Bati is a rat. Very explosive statement, very catchy statement. But Nigerians must not miss the three words immediately before the accusation. My working theory. That tells you Arnold is presenting an interpretation, not announcing the result of an FBI investigation. And this is exactly where Nigerian political discussion normally goes wrong. Somebody presents a theory. A blog reports the theory. Somebody screenshots the headline. Another person posts, breaking, America confirms Tinubu was FBI informant. Before evening, millions of people are arguing over something nobody actually confirmed. That is how misinformation grows. Now, there is another part of this story involving Atiku Abubakar. Atiku has responded strongly to the FBI's argument that releasing some information could endanger lives. And remember, Atiku is not a neutral observer here. He is running against Tinubu in the 2027 presidential election. So naturally, this controversy has enormous political value to his campaign. According to the information we have, Atiku, through his senior special assistant on public communication, Frank Shaibu, argued that Nigerians are already dying under Tinubu's administration. His position is essentially that Nigerians should not be expected to accept a broad danger to lives argument while citizens themselves are dealing with insecurity and serious economic hardship. I understand the political point Atiku is making, but legally, those are two separate matters. The FBI's FOIA argument concerns whether releasing particular law enforcement information could expose somebody to a specific safety risk. Nigeria's economic hardship and insecurity are questions about Tinubu's performance as president. One does not legally cancel the other. You can hold Tinubu responsible for failures of his government where responsibility is established while still recognizing that somebody named in an old investigative file could face danger if sensitive information is disclosed. Those two conversations can exist together. Atiku should challenge Tinubu's record. That is his job as an opposition candidate. If people are suffering, challenge the government. If insecurity remains unacceptable, challenge the government. If economic policies are hurting ordinary Nigerians, challenge them. But that does not automatically determine whether an American FOIA exemption is legally justified. Judge Howell will determine that according to American law. And Nigerians should remember something else. The FBI has not simply been given unlimited permission to bury everything forever. There is a court process. The judge has deadlines. Arguments are being filed. The government must justify withholding information. Aaron Greenspan is challenging the withholding. Tinubu has legal representation. And the judge can examine information privately. That is very different from one politician simply announcing, case closed. Now let us return to Arnold's argument that America doesn't work like Nigeria. I would not romanticize America either. America has had corruption. America has had abuse of power. America has had wrongful prosecutions. America has had intelligence scandals. No country should be treated as morally perfect. But there is something Nigeria should learn from this entire situation. Institutions matter. Think about what is happening. An individual asks powerful federal agencies for records. The agencies refuse. He challenges them. He takes them to court. A federal judge tells some of those agencies that the earlier refusal was improper. They return with different legal exemptions. The judge then examines whether those exemptions are legitimate. And this controversy involves the sitting president of another country. That is institutional process. Nigeria desperately needs institutions where citizens can challenge government secrecy without everybody immediately asking, who sent you? Which party do you belong to? Who paid the judge? Who controls the agency? Because when citizens lose confidence in institutions, every decision becomes conspiracy. If EFCC investigates an opposition politician, people say Tinubu sent EFCC. If EFCC investigates somebody in APC, another group says there is an internal political fight. If INEC makes a decision, one side says it has been captured. If a court gives judgment, the losing side sometimes immediately alleges corruption. A democracy cannot remain healthy when nobody trusts anything. And that brings us back to President Tinubu himself. If there are records about his past that can lawfully be released without genuinely putting innocent people in danger or damaging legitimate law enforcement interests, then I believe transparency is better. Let Nigerians see what can legally be seen, because secrecy creates speculation, and every additional attempt to withhold information will naturally create more questions. But if the FBI can demonstrate to Judge Howell that releasing particular names or details could genuinely get somebody killed, then the court has a responsibility to consider that too. Transparency does not mean recklessness. You can release legitimate public information while protecting witnesses, informants, agents, or innocent third parties, where the law requires it. And remember, even if we eventually discover that somebody was an informant, that alone would not automatically prove every other allegation being circulated online. You would still need to establish what happened, who was involved, what information was provided, under what circumstances. Was there an agreement? Was there prosecution? Was there immunity? What do the actual documents say? Evidence must build the conclusion. The conclusion cannot manufacture the evidence. Now, politically, Tinubu has a problem here, whether he likes it or not. This controversy is now entering the 2027 campaign. Atiku's camp will use it. Other opposition groups will use it. Tinubu's supporters will fight back. And every new American court filing will become Nigerian campaign material. But the opposition should be careful too. Because if you exaggerate this case beyond what the evidence establishes and the documents eventually fail to support your biggest accusations, you could hand Tinubu an opportunity to say, "I told you they were lying about everything." That would be politically foolish. Stick to what can be proven. There are already enough legitimate questions. You don't need to invent answers, and Tinubu's supporters should stop behaving as though asking those questions is somehow an attack on the president. He is seeking another 4 years. Nigerians have every right to examine his record, his history, his policies and controversies surrounding him. That is democracy. The same applies to Atiku. The same applies to Peter Obi. The same applies to Kwankwaso. Anybody asking Nigerians for the keys to Aso Rock should expect uncomfortable questions. So where exactly are we now? The FBI says certain information requires protection because disclosure could expose investigative techniques or create danger to life or physical safety. Mike Arnold accepts that such a legal justification could be plausible, but then develops his own theory that an informant may be at the center of the secrecy. He goes further and theorizes that the informant could be Tinubu. He speculates that Tinubu could have provided information about other people involved in an alleged network. He even wonders whether those alleged disclosures could have extended to prominent Nigerians or international criminal networks. But Arnold himself acknowledges that this is his theory. Atiku, meanwhile, is challenging the FBI's danger to lives argument politically, pointing to Nigerians suffering from insecurity and economic hardship under Tinubu. And behind everything sits George Beryl Howell. That is where the real answers matter, not Mike Arnold, not Atiku, not APC supporters, not Tinubu's opponents, not Twitter. The evidence. If the FBI eventually tells the judge privately who could be endangered, the public may still never see every detail. That is possible. The judge could allow some information to remain protected while ordering other information released. That is why people should prepare themselves for an outcome that is not simply release everything or release nothing. There could be redactions. There could be partial disclosures. There could be protected names. There could be additional litigation. This story may continue for some time, but there is one question that will continue following this case until somebody provides a credible answer. What exactly is so sensitive in these decades-old records that the FBI believes disclosure could still endanger somebody today? That question is legitimate, and Nigerians deserve to follow the answer wherever the evidence leads. If it clears Tinubu, say it. If it raises serious questions about Tinubu, ask him to answer them. If Arnold's theory turns out to be wrong, say it. If evidence eventually supports any part of it, examine that evidence. No political worship, no automatic conviction, no automatic defense because somebody occupies Aso Rock, and no turning theories into facts because they favor the candidate you support. For now, Mike Arnold has introduced an explosive theory into an already explosive controversy. But a theory remains a theory until evidence turns it into something more. And as this American court battle continues, Nigerians should watch the documents very carefully. Because ultimately, those documents, not political propaganda from either side, will determine how much of this mystery can actually be proven.